All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good afternoon, everyone. We're here on oral argument in our second case on the docket, which is 1 CACB 160739 GRADY'S versus Alliance. I would remind the parties that these proceedings are being audio and video recorded. So when you approach the podium, if you would please identify yourself and your client. Each side will have 20 minutes to present their argument here today. Appellant's counsel is responsible for watching the clock to make sure that you have time remaining if you wish to save a portion of that time for rebuttal. We have read the briefs. We have conferenced this case. And Mr. Kelly, you may proceed.
Thank you. May it please the Court, Jason Kelly for the plaintiff and appellant, GRADY'S Quality Excavating. And I will try to save some time for rebuttal, but at the same time I don't know that my prepared remarks are that long anyway. This really comes down to what I see are inadequate findings of fact and conclusions of law. The case law, and we've cited it, and I brought some particulars here in case there's questions, but the case law says that the trial court needs to give the Court of Appeals and the parties essentially a roadmap of what happened and why he came to the decisions he came to. It's undisputed that GRADY'S did its work on this construction project. This is on, I believe, page 136 of the transcript from 4/1/16, April 1st, where Mr. Ron Gardner, the primary principal owner of the defendant Alliance, said, under questioning, I asked him, didn't GRADY'S do this? Didn't GRADY'S do that? Didn't GRADY'S do this? He said, yes, yes, yes. He eventually said on page 136 they did the whole job. And for that job, there was a set contract price. So he agreed they did the job. He signed a piece of paper that said, I'll pay you X. At trial, there was questions and some concessions on our part that certain portions of the work should be deducted from that contract price. The law has also gone undisputed that to deduct from the agreed upon contract price, Alliance had the burden of proof.
Didn't the subcontract specifically provide that your client would be responsible for the labor costs involved in the project?
For the labor costs according to which, the labor costs as part of its scope of the work.
Well, and that's what I'm sorry, I should have been more clear.
Right.
The scope of work that which they were to provide under the subcontract, they being GRADY'S, that they would be responsible for the labor costs.
Correct.
Okay. And there were certain deductions that were attributable to labor that was requested by Alliance, correct?
Alliance had its own payroll and its own people on the job.
Well, that may be true, but if they were doing labor for the scope of work for your client, then why under the subcontract would they not be responsible for paying the labor costs, regardless of whose employees they were?
If it was labor that GRADY'S to perform, we would agree. Okay. And this is where the factual dispute occurs. And this is why, frankly, it's a really simple accounting exercise that the trial court failed to do. GRADY'S is entitled to X minus A, B, C, D, E. Instead of doing that...
Hold on, you're getting ahead of yourself.
Okay.
So, in all of the labor expenditures that were offset or by Alliance, what expenditures would you say were not related to scope of work under the subcontract?
We're not. I put this in the brief. Let me find the exact page because we did do what we believe was correct. But as I'm looking, let me point out, this is part of the problem with the way the case has been framed by both Alliance and the trial judge. The deduction, it is not Grady's obligation to disprove, to prove that Alliance is not entitled to deductions. It's Alliance's burden to say these are the deductions that should be made. What we did at trial and what I put in the...
Oh, wait a minute, because, again, I don't want you to get too far ahead of the specific questions that I'm asking, and that is, there were certain labor costs that were going to be Grady's responsibility.
Correct.
Both sides recognize that as I read the transcripts.
Correct.
And what is in the transcripts that would indicate that the costs that Alliance said were labor costs as it relates to the project, was the scope of the subcontract, were not, in fact, labor costs that were subject to scope?
I'm not, with all due respect, I'm not getting ahead of myself, and Your Honor's question hits the nail on the head, because that argument is the prior verbal agreement of the parties, which is inadmissible under the parole evidence rule.
You just told me that the labor costs were under the subcontract were to be paid for by your client.
Not the labor costs. Some of the labor costs.
Say that in the subcontract. Point to me in the subcontract where it says some of the labor costs, and it denotes that you're not going to be responsible for the labor costs. Because when I read the four corners of that subcontract, I see that it's the labor costs that your client was responsible for.
I have to respectfully disagree.
That's fine. That's why I said show me where it's not.
The contract has a scope of what to do.
Correct.
Grady's is required to do that, no matter what their labor costs are. If it costs them $1, if it costs them $1 million, they have to do that. They've agreed to it for a price.
And pay the labor cost to get that scope of work done.
That's what I'm saying is that's built into what they're supposed to do. If, for example, scope A is Grady's scope, scope B is Alliance's scope, necessarily Grady's has to pay all the labor with scope A. Necessarily, Alliance has to pay all the labor with scope B. The agreement that Grady's was to cover all the labor costs.
Section 1 of your subcontract says the subcontractor shall furnish all labor materials excluding asphalt and equipment necessary and perform supervision of labor required for the completion of the phase of the project identified and itemized on attached Schedule A.
Schedule A.
Okay. So
they're responsible for the labor within Schedule A.
So Judge McMurdy is asking.
Correct.
Sorry, Judge McMurdy is asking you. Give us an example, your best example of work that was attributed or deducted, and setting aside your burden argument, which I understand, but work that was deducted from that total payment that wasn't work done for Schedule A, or on the scope of the project set forth in Schedule A.
So, okay. With all due respect, you can't set aside the burden issue. It's not my client's, I'll get this to the contract. It's not my client's responsibility to prove that the other side's not entitled to deductions. So the scope,
but your
client's
burden to prove that the contract was breached, and if the contract says, we'll give you $361,000 and you'll pay for all the labor, right? And this contract also specifically says if contractor has to provide labor, they can deduct it. Why isn't that all part of determining whether the contract was breached, which would be your burden to prove?
Because we have, well, this is the second part of the brief, we have a couple statutes, one of which is in play, I think probably both, but both statutes, what we've called the Prompt Pay Act and what we've called the Little Miller Act, both have a process by which you make pay applications. And you say, I've done this work, will you pay me? And if you haven't done the work under the Prompt Pay Act, you either supply a reasonably detailed notice of what was not given, or you don't, under the Little Miller Act, you don't certify it to the owner that the work was performed. As the work was progressing, the pay applications were submitted. Granted, my personnel at my client's office were assisting personnel at Alliance's office doing it, but he signed it, and they were all incorporated in the final bid. And at best, there's one objection to the last pay application, which does not set forth anything in reasonable detail. I mean,
So you disagree with the trial court's fact finding 51, ASI timely objected to Grady's pay applications?
There is, and this is covered in the briefs, there's Exhibit 543, which Mr. Gardner said he might have even created after his deposition. There's no evidence that it was delivered. But even assuming those give him the benefit of doubt and uphold the trial court's findings, there still needs to be a reasonable, detailed explanation of the objection. And this objection was, I'm not paying anything, even though on that same day of testimony, he agreed that my client did all of its work. This is page 136 of the April 1st. He said, your client did all the work. So it's.
But aren't those two separate things? Yeah, we did all the work, but you still were responsible for the labor costs that Alliance said that they paid.
And to the extent that they can show that they paid laborers for Grady's scope of work, that should be deducted. That cannot be discerned from anything within the findings of fact. And if you look at the conclusions of law, the judge even, I would submit, made a contrary statement. Early on, he says, I excluded parole evidence. But then, which, again, the undisputed law says course of conduct is also parole evidence. But then he says, based on the course of conduct, they're allowed to make sure they make a profit on, this was on the last page in our conclusion of law, Alliance is allowed to protect itself from losses on the project, which is the prior verbal agreement.
It's also in the contract.
I do not believe, there are parts in the contract that say if there's a lien claim, we can deduct money to pay out that lien claim. It says if there's governmental penalties, we can deduct money to cover those governmental penalties. That's what that says. That's not related, that's not related to protecting myself to make sure I have a profitable job.
I don't want to, if you want to keep talking about this, I'm more than happy to let you, but I want you to walk me through the fee issue a little bit, if you could turn to the issue of legal fees on this one. Because it seems to me that you raise an interesting issue on appeal that you didn't raise below.
Well, I will concede it was not raised on below. It was not raised below. So, and I can't make the argument otherwise. So what we're doing is asking the court in its prudential, equitable sense to take a look at an issue that was omitted. And the argument is simply that the terms were incorporated from the prime contract into the subcontract, and it doesn't permit the fee shifting.
How do you get there, counsel? I see the subcontract as Section 6, which makes reference to the general. And the general has a waiver of attorney's fees. And you're not arguing those two contracts are a single contract, are you?
No, we're arguing that when it's incorporated by reference, it becomes part of.
Sure. But it's the specific language that becomes part of, not the concept, correct?
I would agree with that, yes.
And doesn't the specific language of the general say the parties herein expressly covenant and agree that in the event of litigation arising from this contract, neither party would get fees? How would that govern the subcontract, which is a separate contract?
Well, because we did cross this bridge earlier in the case, and it is part of the record. When I requested a jury trial, it was denied on the basis that the prime contract had a waiver of jury trial, and it was expressly incorporated into all subcontracts. I don't have the record number in front of me, I apologize, but that is part of the record. I would submit, number one, that would be consistent.
I thought, if I could, I thought
Sure.
I heard you say that they're separate contracts. They're not one contract. Just a minute.
The one's incorporated by reference.
A minute ago. But you said the waiver was incorporated, and my question is it the waiver or is it the express term? And in other words, a cleanest way would have been for the sub to say, neither party shall get fees or costs, to have, what is it, 28 or 26 read more completely. Fair?
Well, I think I would agree. I think the portion you're referring to, Your Honor, is an indemnity, not a fee-shifting clause.
That's 8, I think, yeah. And I understand your point that that's indemnity, not fee-shifting. But I thought in the sub there was a provision later on in there, and I forget the precise. It's 26. Talks about fees and talks about Alliance's ability to get fees, but that's kind of it, right?
Right.
And it doesn't say, oh, and by the way, no other fees are authorized under this, right?
Correct.
Or your argument would be different, right? I mean, it'd be cleaner.
Correct.
But your argument is that I think would have to be that the concept of fee waivers in the general provision, the general contract, has to apply to the sub, as opposed to the specific language of the general has to apply to the subcontract.
Well, I think the prime contract or the general contract says that all of the terms of the prime contract are incorporated into all the subs, and to the extent there's a dispute that the prime controls, and as
doesn't it say something a little different than that? Doesn't it say that they should be incorporated in the subcontracts, as opposed to they are?
Well, if I can't answer that. I had not reviewed the should
text,
be versus are. I have not reviewed that, Your Honor.
But it's an express term, and whatever the general or the primary contract says would govern. Is that fair?
Whatever our position is, if it's required, if it's in the prime and there's something contrary in the sub, the prime controls.
Okay.
And the reason I brought up jury trial, because I lost this very argument at the trial court, and he said, no, you're not entitled to a jury. And frankly,
you haven't raised that issue, so that issue isn't specifically before us.
That would be consistent with the trial judge's interpretation of the contract. Our final argument in our brief is consistent with how the trial judge interpreted the application of the prime contract to the subcontract vis-a-vis the jury issue.
But doesn't that go to the issue that perhaps if you had raised this argument in the trial court would have agreed with you, but you didn't, so it's waived?
Well, I understand that argument. I'm submitting that this is a big issue that we were asking the Court of Appeals to look at, and I understand if the Court of Appeals takes the position it wasn't raised, there's only so much I can do about that. I do want.
If I may, just
sure.
You not only did you not specifically raise this issue in the trial court, but you requested fees yourself in the trial court. Correct?
Yes.
So you're actually taking a factual position different before us than you took before the trial court. Because factually, before the trial court, you said we can get fees under this contract. We can get fees. Contract and the statute.
We pled it in the complaint, correct.
Okay.
We never made an application for fees.
Well, because you lost.
Which wouldn't have, right. Correct. So, I would disagree with the fact argument. I agree it was pled. I would disagree with the statement that we, made the application, but we took a different factual position. I mean, we pled it in the complaint out of an abundance of caution.
And then you asked for fees on appeal as well.
Well, to the extent we've waived it or we're wrong, we believe we're asking for fees in the alternative.
Okay, so your argument is, if you guys find it's waived below, but we prevail on appeal, we would ask you to go ahead and...
Or if you decide to take it and you decide I'm wrong, then in the alternative, and I still win substantively, and if I'm wrong on that point, I believe we're allowed to make requests in the alternative.
Are you judicially stopped from making these? I mean, these are very distinct, different claims that you raised in your petition below and that you're raising here on how to interpret this.
I think judicial estoppel only applies where you've prevailed in the first instance,
okay.
As I recall the doctrine. Unless there's any more questions, I'll try to save the last minute or so of time.
All right. Thank you, Mr. Keller. Counsel.
Thank you, Your Honor. May it please the Court, my name is Sharon Shively. I represent Alliance Streetworks and its surety North American Specialty Insurance Company. What Mr. Kelly is advocating for here is for you to review the facts as he wants them to be, not as the trial judge found them to be. He wants you to substitute your judgment for the trial court's judgment. This was a 5-day bench trial, numerous witnesses, hundreds of exhibits, and the judge made it clear in his opinion that he had been able and had examined and studied the witnesses' demeanor, their body language, their responses to questions, their explanation of the numerous documents, and he specifically repeated that when he denied their motion for new trial as well. The subcontract was clear, Your Honors, and I understand that you focused on that because that's what you need to focus on. The judge did not enter, and as a matter of fact, struck any parole evidence that had been originally admitted for his ability to judge whether or not it should be excluded or not, and he did in fact exclude it. The subcontract was clear that Grady's was to furnish all labor and materials, excluding asphalt, and equipment necessary and perform the supervision and the labor for the completion of the phase of the project that was listed on Schedule A. Schedule A was the entire project. Alliance had no responsibility for labor at all.
But if the trial judge erred in assigning the burdens of proof, and I'm not saying that he did, but if the trial judge should have put the burden upon your client to prove the offsets. In other words, we've got a contract that says $361,000 minus whatever you all incurred that they should have paid. There's nothing in the findings and fact of conclusions of law indicating where he assigned that burden or how he assigned that burden. So why wouldn't we send it back to him to say, you need to tell us whether you assigned the burden correctly in this case?
Well, the first thing he did in his judgment was he granted our motion, our Rule 52C motion. Now, he did it at the end of the case. It was raised, obviously, after the plaintiff rested. But he ultimately granted that. So he concluded that no matter what, Mr. Kelly's client had not met its burden of proof that there was any breach of contract by Alliance. At the same time, Alliance did go forward and present its case, and it had...
Well, as a matter of law, which is the correct answer? Is it, obviously they have to show, they have a burden to prove that the contract was breached.
Which they failed to do.
Who has the burden of proving the offsets?
I think Alliance had the burden of proving the offsets, Your Honor, and Alliance did prove the burden of its offsets. And the trial court made 65 findings of fact, 55 of which had to do with the Grady's affirmative claim. As part of that, he concluded...
Well, I'm sorry, and I don't want to be rude, and I'm...
No, that's fine.
Okay. If you're conceding then that Alliance had the burden of proving offsets, why wouldn't Grady's have met their burden just by showing we didn't get a check for $361,000? Now it's on them to show what was a appropriate reduction from that. So they would prove that the contract was breached by showing we didn't get our $361,000, and then you guys have to prove what was a correct reduction.
Because in their case in chief on cross-examination, I was able to demonstrate that all the expenses, all the equipment charges, all the labor charges, and all of those other expenses had been paid for by Alliance, and that Alliance, under the contract, was entitled to full reimbursement of every one of those charges. So that was all produced on their case in chief. The judge did go forward and heard all of the evidence, and we supplied, and I think as an exhibit to our motion for new trial, which is in our appendix, we have shown every single document that supported every expense, every labor charge, every use of equipment that Alliance had paid for because Grady's was not paying for anything. And don't forget, it was Alliance's bond that was at stake. It was Alliance's financial wherewithal that was keeping this contract together. So he had no choice, Alliance had no choice but to make all those payments. And the Grady's subcontract, which Grady's drafted, this is their contract, and they are the ones, Mrs. Hobson herself, specifically put in the Schedule A that any and all payrolls and expenses paid by Alliance on behalf of Grady's shall be deducted from the total of Grady's subcontract amount. And we showed on their case in chief that is exactly what we did, and we came out with actually a negative balance. Money was lost on this contract.
Okay.
So if you view the facts in the light most favorable to upholding the judgment, the numbers of findings of fact, the judge takes it through 55 steps showing exactly how he arrived and he gave you the ultimate facts, and then the transcript and the records provide all of the individual facts that taken together reach that ultimate fact.
Counsel, the sort of worksheet that you have that tied things that I think you're making reference to, I have it as Exhibit G with some supporting documentation.
Correct. I think there are a few others as well.
And I think that was, and that's actually one of the points of my question. That was, I think, in connection with the motion for new trial work. Was that a trial exhibit, the Exhibit G, with the sort of tie-in, or was there a demonstrative?
It was a demonstrative trial exhibit, but it wasn't admitted into evidence.
So is that, when we teach sort of making the record, is that the infamous, here's an easel with some numbers on it and it just doesn't appear of record by the time it hits us? Where would we find that reference?
What you would, the reference to that?
To that the trial judge had before the findings of fact and conclusions of law were issued.
I don't know if that would show up. It should show up in the transcripts. If it doesn't, then each individual exhibit, because if you look at exhibits G, K, and F, you'll see that each exhibit
and I see the tie-in
is tied together.
What I look for, and I don't see it in the findings of fact and conclusions of law, is show me your work. How'd you do the math? I see conclusions in there, but I don't see sort of the here's where we start and here's what we deduct and here's how you get there. Exhibit G shows me that. It just seems that came at the 13th hour, not before that. And that was why I wanted to make sure I understood the procedural
I think that is how it happened. The judge was obviously taking voluminous notes as he went through, and as every expense was admitted into evidence and proven that Alliance had paid it along with the invoice and the check. And, he was writing all of that down. So, I mean, one can, I think, has to assume in favor of the trial judge that he did that calculation, because there's no other way he would have been able to conclude that there was no money due Grady's. And, in fact, the project had a negative balance. With regard to the Prompt Pay Act, the Private Prompt Pay Act, we know for sure, as of November 16th, 2017, we know that no longer never applied to public construction projects. This court issued a decision in Zumar Industries v. Camus Corporation on that day, and in which it held that the Private Prompt Pay Act has expressly does not apply to state government jobs that the Little Miller Act does. So that, at least I think that case had to do with a federal construction project, but this court had also concluded that the Private Prompt Pay Act would not apply to state project. So I think that issue is off the table. Now, the Miller Act does apply. The judge concluded that Alliance had objected to the pay applications. In fact, pay applications number 1 and 2 were not necessarily objected to because they were paid. If you look at the January pay application, which is in our appendix starting at A387, and it was prepared by Grady's itself. And you'll see the memo that accompanied it, and you'll see the spreadsheet that shows how Grady's was applying for its funds. And it asked for, Mrs. Hobson specifically asked for, $36,370.64, and she said, this is the amount I would like to be paid now. This is what is left after everyone else got paid. She knew and was acknowledging all the way through, there are tons of emails in the record, and many are in our appendix, that show she understood exactly what Schedule A meant, that all expenses, labor, equipment, was coming off of their subcontract, because Alliance was only paying for materials, and only some materials at that. And she asked for the $36,000 and change, and the next day she got a check for that exact amount. When the next pay application hit in February, that's the one that Alliance objected to, and on each line item of the pay application, which is in our appendix, and it's very difficult to read because of the way it was copied, but in the record it's clear, and I have a clear copy for the court if it wants it. Under each line item, it specifically says, rejected, Alliance paid for all of these expenses and labor charges. So that was objected to. So, and in any event, and the Miller Act does apply, we did object to the pay applications, but even if for some reason we didn't object, the court found we did, but even if we didn't, the remedy isn't that they all of a sudden get $361,000. The remedy is they get 18% interest once they prove there's actually a breach of contract, and they're entitled to a recovery. That's the only penalty, or maybe a referral to the Arizona Register of Contractors. But that's the only penalty associated with a violation of the Prompt Pay Act.
Counsel, if I could, because I want to make sure we discuss this before we run out of time.
Sure.
Could you respond to their argument regarding the fee shifting provisions of both the prime and the subcontract?
I was just getting there. Yes, obviously, from the very, very beginning of the case, they waived that argument. They have repeatedly requested fees themselves. They never raised it before the trial court. And I think Judge Thuma is correct that in the prime sorry.
It's okay.
You should see what people do to Shively.
That's why I didn't say it.
I'm just so new here. I've been corrected so many times.
I appreciate that, and I apologize. He raises the argument that the prime contract specification, I think the judge hit it on the head when he said that particular provision of the prime contract refers to that contract in and of itself. The GRADY'S contract, again, it's their contract. This wasn't Alliance's contract, so it's construed against them in any event. Provides.
Why wouldn't you be judicially estopped, just playing off the question he asked earlier and the comments of your opposing counsel? You guys invoked it to avoid a jury trial. Why would you then not be bound by the provisions of the prime contract?
Because there was nothing in the I'm sorry, Your Honor, I didn't mean to interrupt. There's nothing in the subcontract that addresses jury trial. So that particular flow down provision can flow down. There's no conflict.
There's nothing in the subcontract that addresses jury fees when they're sought when that side initiated suit.
Attorney's fees.
Attorney's fees, sorry.
Right.
I'm sorry, say that again?
But you said there's nothing in the subcontract that addresses a jury trial. As I read the subcontract, there's nothing in it that addresses whether you guys would be entitled to jury fee or attorney's fees when they've initiated the lawsuit.
The provision is a little ambiguous, I grant you, but we also asked for fees on two other bases. One was the Arizona statute, 341.01, and the other was under the terms of the bond and ARS section 34.222.
But you invoked the prime contract to avoid a jury trial. Why wouldn't you be bound by it with respect to the fee shifting provision?
Because our argument is that the subcontract does address fees, and the statute addresses fees, and the prime contract specifically talks about that
statute that
contract.
addresses jury trials, too.
Counsel, if I can follow up on Judge
Sure.
Morse's question. The subcontract does address attorney's fees, but not in a symmetrical way and not in a way that would authorize the fee award to your client here. Would you agree with that?
I think the way it's written is ambiguous. I think it can be read that way, yes.
Bear with me. Let's
Sure.
assume we were to find that it allows fees to flow the other way, but not the way that they flowed here. Because as I read it, that's what it does. But that then, at least arguably, with nothing else out there, would leave a gap that might allow a cut to 12.340.101. Fair?
Correct.
But here, you have the prime contract saying, just to quote, parties here too expressly covenant agree that in the event of litigation arising from the contract, neither party will be entitled to an award. The contractor further agrees this provision shall be contained in all subcontracts related to the project that is the subject of this contract. To follow up with Judge Morse's question, if you take those two together, there's at least a healthy argument that the general or the prime contract displaces 12.340.101 in a way that would not have allowed the fee award here. What is your response to that?
Well, I think a fee award would still be allowed under the Little Miller Act, because that is a mandatory, that's not a discretionary fee statute, that's a mandatory fee statute.
And is there any indication that the trial court awarded fees under the Little Miller Act? I don't see it from the record.
I didn't see it in there. We asked for it under that. We asked for it under 3 different scenarios.
And it seems to me,
I don't
my
know which you
recollection
did.
is the award was, the quote is something like under the subcontract. Which leaves it a little open in my mind as to whether it was the contract terms, which would be sort of unique, or whether it was 12.340.101. I didn't see a way that the Miller Act sort of snuck in there.
And I agree that. I agree with that, Your Honor, and that's the problem with him not having raised this issue below. It didn't give the judge an opportunity to parse through that any further.
What then does that do for your request for fees on appeal?
I believe we're entitled to fees on appeal. Having been the successful party below and hopefully the successful party here, I think for the same reason, under the terms of the bond, under the terms of 12.340.101, and potentially under the judge's interpretation of the subcontract, but we don't know that.
But we wouldn't be bound by any of that. In other words, to the extent there was a waiver, and you heard the other side being asked about waiver of the fee issue in front of the trial court, that wouldn't have a carryover effect here, would it? We could look at that anew. For fees on appeal, just to clarify.
I suppose that's true for fees on appeal. But again, I mean, GRADY'S has asked for fees on appeal. They've asked for fees in the trial court. They asked for fees all the way along in every motion that they filed, in the motion for summary judgment they filed, which they lost. They've completely waived it throughout. We don't actually know exactly how the judge arrived at his, we know how he mathematically arrived at the number, but we don't know substantively how he arrived at his decision because he was never challenged on it.
Well, but it's, to follow up, but it's a separate issue. Now, the question that was asked is, okay, assuming that we find waiver on the argument below, does that preclude them from making the argument on appeal as it relates to an award of attorney's fees on appeal?
I think it's still a waiver argument, Your Honor, but I can't point you to any authority that says that, quite frankly.
Well, let me give you a question. Then in a recent case out of this court where we found that the fees were waived, the request for fees argument was waived below. The name of the case is Bobrow versus Bobrow. We then nonetheless, for fees on appeal, addressed the substance of the argument raised. With that in mind, does that change your analysis?
Obviously it does, Your Honor, yeah. And I appreciate the education.
So, assuming that we won't find waiver for appeal, and I'm not suggesting that's at all what we're going to do, what is your best argument for interpreting the contract to say that your client was entitled or is entitled to fees on appeal just by the terms of the contracts?
The subcontract itself.
Yes,
but okay, well, I don't think that it flows down.
Subcontract as incorporating whatever it incorporates from the prime.
Given that the subcontract was prepared by Grady's. It's their standard form subcontract. I think it's construed against them. I don't think that the flow down provision from the general contract, from the prime contract, flows down in such a way to prevent that. I read both the indemnification provision, frankly, and the attorney's fees provision to be able, for Alliance to be able to be awarded its fees.
All right. Thank you very much, counsel.
Thank you.
Thank you.
Mr. Kelly.
I'd like to focus on the first couple questions Judge Morse asked about who bears the burden in these issues. And this really goes to the findings of fact and conclusions of law. Where was the math? He zeroed it out. He somehow figured that there was no money owed to Grady's. And without having the math and saying you need to deduct X, Y, and Z from the contract, the only way he could come to that conclusion is enforcement of the prior verbal agreement. And that's really the parole evidence rule plus, and I'll talk about the Little Miller Act in a little bit. The parole evidence rule and the Little Miller Act require this sort of accounting. Under the Little, and this is on pages, I think, 28 to 30 of my opening brief. Under ARS 34-221 paragraph I, it says if the general contractor incorporates the pay application from the sub to the owner, they've certified the work's done. And this reasonable Prompt Pay Act and all that stuff, objection doesn't even apply. Once it's certified to the owner, says to the owner, Grady's did this much work, then they've certified it's done. And this is and we cited the construction law handbook that Ms. Shively edits. And once they get paid, once the general gets paid, they're to pay the sub in 7 days. So the way you don't, and the idea is, because Grady's can't pay
Kelly,
its...
your time has expired.
I'm sorry.
Thank you very much. The matter is deemed submitted. We'll issue a decision in due course.